We should begin. Good afternoon. This is nationally recognized as Constitution Day, and the program on public law is tremendously pleased to have Walter Dellinger deliver an address in honor of that occasion. Walter is not only one of the giants in the history of this law school, he's really one of the giants in the American legal community for our generation. He's a graduate of Yale Law School. He clerked for Hugo Black on the Supreme Court. He began teaching at Duke, if I'm right, in 1969. And in addition to teaching here for so many years, where he served as the Douglas Maggs Professor of Law, he also served in the government in top roles. He was the Assistant Attorney General of the United States Department of Justice, in charge of the Office of Legal Counsel. He was the Acting Solicitor General of the United States. He's argued about 20 cases in the United States Supreme Court. He's head of the Appellate Litigation Section, the firm of Melvin E. Myers, and it's always wonderful when he's back here to speak, and we all look forward to listening to you today. Walter Dellinger.
Thank you. On the 5th of July, 1787, the Constitutional Convention returned from the only break it took during the summer. Yes, even in 1787, they were celebrating the 4th of July, celebrating a dozen years earlier the fractious alliance that they formed with the Declaration of Independence. And things did not bode well for the Constitutional Convention when they returned. The Gouverneur Morris of Pennsylvania spoke to his colleagues at that time and said, because he feared, as others did, that the convention's work, which had begun on May 25th, would end without any plan or any revision or any suggestion or any coherent outcome at all. So divided were the delegates over a number of issues. And here is what Morris said to his colleagues on the 5th of July. He came here as a representative of America. He flattered himself he came here in some degree as a representative of the whole human race. For the whole human race will be affected by the proceedings of this convention. Now, we may well doubt that this small group of affluent white men of property could, in fact, represent the whole human race. But he was none the less correct that the whole human race would be affected by the outcome of the proceedings. The country must be united, he went on. If persuasion does not unite it, the sword will. He begged that this consideration might have its due weight. The scenes of horror attending civil commotion cannot be described, and the conclusion of them will be worse than the terms of their continuance. The stronger party will then make traitors of the weaker, and the gallows and halter will finish the work of the sword. It's an extraordinarily apocalyptic vision of what could transpire in America in the summer of 1787, and yet not a single delegate said that's too dire a prediction, that we would have the stronger party make traitors of the weaker and the gallows and the halter finish the work of the sword. But it gives you a sense, because only 2 years later, the French Revolution was to spin out of control. And the guillotine did finish the work in large measure. Those who met in Philadelphia were moved not only by fears, but hopes as well, and by visions of the grandeur and importance of America. One of my, well, unquestionably my favorite teaching experience was the 7 years that I taught constitutional history here along with John Hope Franklin and William Leuchtenberg, which I started to finish the work. Chris Schrader and I tried to read the debates in the Constitutional Convention starting on May 25th one summer and to read each day's work, but even that project failed. So I fell back on the last refuge of a professor, which is to schedule a class and assign the next 50 pages for every class, and you have to read it or be utterly mortified in class when you call on yourself and say you're not prepared. So I did, and for those 7 years, we simply read the debates in the Constitutional Convention, Madison's account of them, taking a seat very near the front, and losing not a moment between the end of one session and the beginning of another. While everybody else was out drinking ale at Ms. Grundy's in Philadelphia, he was retranscribing his notes every night. He was our first political scientist and our first overeager student of the new generation. But to read those accounts, to go through the debates at the convention, is to really enter another time and place and to gain a sense, partial, obscure, and clouded, to be sure, but to gain a sense of a truly extraordinary event in at least the political history of our people. When you watch the Constitution unfold, you're exposed to statecraft of the highest order. You see in the records of the convention, and you can actually look at it in Madison's own hand, truly gifted public discourse, a quality that leaves one really embarrassed about the comparative poverty of the public discourse of our day. But then one has to recall that it was one of those moments in human history where the most talented people, who would have been architects and poets and musicians and scientists, were instead engaged in politics. Can't imagine Thomas Jefferson sort of running for office these days. He would have found other pursuits. But like Václav Havel in his time, this is what the best minds in America did at that time. And as one European said recently, at the beginning of time, America was nothing. You were nothing in art, you were nothing in letters, you were nothing in science, you were nothing in engineering, you were nothing in painting. You had the best statesman in the world. Now, you control the world's culture, and on the other hand, you can finish that thought for yourselves. They were seen, even in their own time, as unusually gifted. I admire the French Chargee d'Affaires wrote home to his government as the meeting convened and said, "If all the delegates named for this convention at Philadelphia are present, we will never have seen, even in Europe, an assembly more respectable for the talents, knowledge, disinterestedness, and patriotism of those who compose it." Their work has lasted longer than any constitution ever written. And yet, here we are, in fact, on September 17th, the anniversary of the last day when the convention sent its work out to ratifying conventions in each state. We are here to celebrate that event, but also to reflect seriously on what the opponents of the Constitution saw to be so wrong with it, and what we in our day can see to be wrong about the work that was done in Philadelphia. I think if occasions like this are meant to be for constitutional renewal, we need to listen to the arguments of those who opposed the Constitution and very nearly succeeded in defeating it, and those who dissented from it, and to reflect upon what was not enduring. And I will recall at the end sort of the lasting legacies that are enduring and positive. But in order to avoid an undue romanticization, let me begin by talking about two aspects of the framing that are discomforting. One is the framers' deep ambivalence about democracy, and the other is the Constitution's accommodation with the institution referred to by one delegate as the curse of heaven. Now, on democracy, listen for a moment to the debates of, you can pick almost any point early in the convention, And the sense you get, to use a phrase I think that originates with Gordon Wood in an essay on democracy and the Constitution, democracy was the problem to which the Constitutional Convention was called to come up with a response. That's the relationship. Democracy was the problem, by which he meant popular democracy, in the view of some delegates, run rampant. What happened when colonial rule was renounced is that those colonies turned states adopted the most democratic constitutions, most populist the world had seen. They had often one-house legislatures, governors with short terms, large assemblies in terms of numbers, so that each person would represent a small local constituency. People were sending their own. One-year terms were common. Instruction by the people of the town or county meeting, instructing you how you vote. Recall was part of some constitutional systems. Weak governors. Elected judges was very important. Elected judges that would be close to and reflect the people's will. And throwing off of rule by London for local rule. So the wariness about, the wariness, however, of the framers that met in Philadelphia was that it was too populist. There was a rumor circulating in Philadelphia. I don't find out whether this is true or not, but there was a rumor among the delegates that Rhode Island, the most populist of the states, the most debtor, farmer friendly, the most property hostile, was considering a bill calling for the equal redistribution of all property every 13 years. Now, to the propertied men that met in Philadelphia, this was not, a great idea. And the debate begins when they're looking at the Virginia plan. Madison arrived with a plan. He arrived at the convention with a plan. He spent the winter of 1785 snowed in up in his mountain home, studying the history of confederacies, ancient and modern. And he came with a plan. And under his plan, the House of Representatives was to be elected by the people. That was the only part of government that was going to be elected by the people of the proposed national government. But the idea that even this one part would be elected by the people was met with an immediately hostile reaction at the convention. Mr. Sherman, Roger Sherman of Connecticut, opposed election by the people, insisting it ought to be by state legislatures. The people, he said, should have as little to do as may be about the government. They lack information and are constantly liable to be misled. Elbridge Gerry was up next. He said, the evils we experience flow from an excess of democracy. The people do not lack virtue, but they're the dupes of pretended patriots. Randolph of Virginia said that the general object was to provide a cure for the evils under which the U.S. labored, that in tracing these evils to their origin, every man had found it in the turbulence and follies of democracy. Now, Madison, who was all for coming up with a national government more removed from the people, Madison's, wait, it's going too far here. Wait. Madison considered the popular election of one branch of the national legislature essential to every plan of free government. That if the first branch of the general legislature should be elected by the state legislatures, the second branch, the Senate, elected by the first, and the executive by the second together with the first, and other appointments, again made for subordinate purposes by the executive, the people would be lost sight of altogether. And the necessary sympathy between them and their rulers and officers too little felt. He was an advocate for the policy of refining the popular appointments by successive filtrations, but thought it might be pushed too far. and Madison's argument prevailed. He also said in his clinching argument that there was a great pyramid. The national government was to be a great pyramid, and it needed to rest on the solid foundation of the people themselves. And he reminded his fellows and reminded us that after all, they would be submitting this for popular ratification. That is, it wasn't going to be sent back to the state legislatures, which were the big losers, but rather it was going to be sent back to, they made up the idea of ratifying conventions in each state to send the document back to. And those conventions were generally had popularly elected delegates who sort of campaigned on whether they were more or less for or against the Constitution. So there was a large but not decisive popular input. So in a sense, they're campaigning for the consent of the governed. The Constitution framers are asking the governed to consent to less government by the people, but for the people to consent to that. And so, but when it was revealed, however many years ago it was today, I can't do the math anymore, 2007, 1787, September, whatever, however many umpteen years it was, 200 and umpteen, 200, on this, the 200th anniversary of the proclamation. When it went out on the 17th, it was printed in newspapers all over the country, the proposed Constitution. What a shock. I mean, we would think now as we genuflect on the day that there would have been dancing in the streets. But in fact, the Constitution had to literally come from behind to win ratification in the critical states. It was rejected in North Carolina. It passed in Madison's own Virginia, 89 to 78, 30 to 27 in New York, and that only after Virginia had already ratified. What did those who opposed the Constitution see that was so wrong with it? Well, they were patriots too, but largely lost to history. People like Melancton Smith in New York, Willie Jones in North Carolina. Patrick Henry we know of, but not because of his opposition to the Constitution, but rather because of his quip about liberty or death from an earlier time. Patrick Henry's first speech was 8 hours long against the Constitution and the ratifying convention. He spent half a day on the first 3 words. We the people. Who are they to speak in terms of we the people? It should be we the states, he said. What is interesting about it is that the opponents of the Constitution and the supporters of the Constitution largely agreed upon the nature of the change its adoption would make. They just fundamentally disagreed over whether that would be a good or a bad move for the country to take. Patrick Henry agreed with Gouverneur Morris's vision and Hamilton's vision that this would be help create a great and mighty empire till time shall be no more, but said, why should that be our goal? Why do we want to emulate those great empire nations? Why do we want simple democracy, an agrarian economy? Why do we wish to emulate that? They also agreed on the fundamental change in the nature of representation that was taking place. And this is a little hard to explain, but it's really fundamental. Let me come at it this way. The one provision of the draft Constitution that caused the most debate and the most opposition would be very surprising to you. It was the simple statement that there would be 65 members of the first House of Representatives, or a number not to exceed, a number of representatives from each state not to exceed 1 per 30 or 40,000. That came out to be a 65-person House of Representatives. With all of this power being transferred to the national government by the Constitution, these 65 individuals and their 26 colleagues in the Senate appointed for Listen, there were people that were really upset by the fact that the term for House members was 2 years, that was far too great a distance from the electorate. Too long a leash. Annual elections, the Palladium of Liberty. 6 years for the Senate, 26 people from the 13 states. But a more galling was 65 House members, because they were replacing more than 3,000 state legislators. Right, there were like 400 members of the Massachusetts legislature, which meant that every small group elected someone of their own. There were all these small constituencies where a group of yeoman farmers, I have no idea what yeoman is, but it always sounds right. Yeoman and I don't know, it's yeoman farmers, yeoman and farmers, but it always has that little ring of antiquity to it. These yeoman farmers would elect a fellow yeoman. But now power was going to be, this whole continental eastern seaboard nation was going to have 65 congressional districts. That's further than a person could ride in several days. And no one, so Melancton Smith opposed it, saying no one will be elected other than someone of conspicuous military or similar achievements. Madison agreed. Madison said, we will have, because of the large districts and a national government, we will have a country led by the worthy and the great. And Melancton Smith used almost identical language to say, I fear that no yeoman or person of common judgment will ever be elected. The country will fall into the hands of the great and the famous. Almost the same language. Melancton Smith has this great discourse in the New York Convention where he opposes ratification, saying that what kind of talents are necessary to wisely make laws? Is it the abstruse knowledge of someone with a refined sense of economics and finance? Or is it a sense that the ordinary people have, a working person would have, of how the burdens of taxation fall upon the people? And he favored the latter as what was necessary for legislation, and thought that you wouldn't get that with this vast terrain. So that was, a major objection at the time, and it was a time when I must say that states' rights made, I would either say more sense, or in some deference to the states' rights crowd, even more sense than it made today. Because what was behind the sense of what were then called the anti-federalists who opposed the Constitution, what was behind it was not just the idea that states should make their own decisions because of some abstract principle, but the fact that at the state level it was still possible to have a different kind of government. The opponents of the Constitution thought that direct democracy was the ideal, and that any falling away from it was caused by necessity. So the closer government was to home, the shorter the terms, the more numerous the legislature, the fewer people electing each constituents, the more you were getting as close as you could to popular democracy. And therefore, at the state level, there could be a different kind of democracy. That's the right to jury trial was so important to them, not as a protection of the defendant, and certainly not in civil litigation. Jury trial was important because it meant that governmental power was imposed if, but only if, you could get a group of people chosen from the community to go along with what the government wanted to do. And it was direct citizen participation in actual government itself. All right, so, what has happened, and at the national level, you couldn't have that kind of politics. At the national level, you could only have really represented Burkean, disinterested, 6-year term statewide senators with the longer vision, which Madison and his allies thought was good. But this is a debate we've had ever since. Now, And Madison had an amazing notion, you can read it in the famous 10th Federalist, that he was worried about the disease most incident to democratic government, we call it Republican government, which was tyranny by the majority. And his answer to the problem of tyranny by the majority was to turn centuries of political science upside down. Political science thought that democracy could work only in a very small geographical area. You could have Athenian democracy within a city, but for a large and vast domain, you needed some other kind of government. But Madison worried about the problem of majority tyranny. And he thought one of the solutions for it, in his view, the principal solution, was to extend the republic across a vast domain. Because there he thought that there would be so many conflicting sub-majorities that you wouldn't have one religious sect which could take over and be oppressive in a small community, he said, would never be able to gain dominance across a great continental empire. So behold, he said, in the extent of the republic, we have the cure for the diseases most incident to republicanism. A rage for paper money, a zeal for a particular religious sect may inflame one constituency, but not create a conflagration across a vast domain. Now, so Madison was filtration of the popular views, but he believed in the bedrock, and he thought it absolutely important that the Constitution be ratified after popular debate in each state. But that then turns us on this celebratory occasion to the fact that the immediate success of the convention rested in part on what was, and I mean this literally, an unspeakable compromise. The issue of slavery did not simply slip past an inattentive convention. And as I taught the debates in the convention, every year I taught it, I could see the slavery issue in the background earlier in the convention. No one mentions it almost until August, but you began to see the shaping of what's going on in the shifting votes with that in the background earlier and earlier. When I said it was literally unspeakable, the reference to 3/5 of all other persons is a typical circumlocution. But while it simmered under the surface, it burst out in August the 8th when Gouverneur Morris gave his Curse of Heaven speech. It was a nefarious institution. It was the curse of heaven on states where it prevailed. What he was opposed to was the notion that slaves would be counted at all in the formula. The 3/5 part, it's the 3 part that he opposed to, because that meant they were not going to be allowed to vote or participate, of course, as slaves, but they would, by their number, being 3/5 of all other persons, add to the size of the delegation and influence of the states that had slavery. So it was the slave states that wanted slaves counted as 5/5 for the purposes of apportioning the House of Representatives, and the non-slave states that wanted only free persons to count in how many legislatures each state was apportioned. The 3/5 clause actually gave the South, the slave states, a controlling authority over the National House of Representatives. And Morris says, the admission of slaves into the representation formula, when fairly explained, comes to this. This is Madison's contemporaneous account of Morris's speech. that the inhabitant of Georgia and South Carolina who goes to the coast of Africa and in defiance of the most sacred laws of humanity tears away his fellow creatures from their dearest connections and damns him to the most cruel bondages, such people shall have more votes in a government instituted for the protection of the rights of mankind than the citizens of Pennsylvania or New Jersey who view with a laudable horror so nefarious a practice. That point, people knew that the issue was cast. But the work was not yet done because the convention had to deal with navigation laws. This was the great, great deal that sealed the convention. And it comes, and this is really when the convention enters the heart of darkness. When the Constitutional Convention makes the country much worse off in terms of slavery than before we had a national constitution. The critical moment came on August 29th. The southern states had wanted to guarantee that they could continue to import slaves from the coast of Africa. The New England states wanted Congress free to enact by simple majorities, quote, navigation legislation, which would be protective legislation protecting the northern shipbuilding and shipping industries. Protective legislation that would be costly to the South, which was, of course, exporting the goods made by slave labor, and wanted free trade. Perhaps it was suggested these two items, navigation and slavery, might, if sent to a committee, form the basis of a bargain. And so it did. The two-thirds requirement for any navigation laws, which would have allowed the South to prevent protective legislation for American shipping and shipbuilding and allow them to ship their goods more cheaply. The two-thirds requirement for navigation legislation was dropped. Congress was expressly prohibited from passing any laws interfering with the importation of slaves before the year 1808. And again, they said the importation of such persons as any state now existing shall choose. Morris said at one point, why don't we say the importation into North Carolina, South Carolina, and Georgia? Name the ones that want the right to do this. But they said, in states now existing shall not be banned before the year 1808. And the slave trade clause was entrenched in the provision on amending the Constitution. You couldn't amend this clause without the consent of every state. It was unamendable. But that is not the last step. Before the business was finally done, one last provision was added. That's the Fugitive Slave Clause. Before the Constitutional Convention of 1787, the non-slave states were under no obligation to return slaves who escaped or persons who escaped from slavery. The Fugitive Slave Clause was the first national commitment to the maintenance of slavery. There's one particular aspect of the drafting of that provision. Every noun in the Constitution, pronoun is he, and it's a commonplace observation that he is used in the Constitution in its generic sense as encompassing both genders. I've always assumed that to be technically true. But the next to final version of the Fugitive Slave Clause puts that in a very different light, because for the only time in the Constitutional Convention, there was a draft, and it was the next to last draft, that used the word she. The pronoun drops out altogether from the final wording, but it's nonetheless extraordinary to find, the convention unanimously adopting as a draft a provision using the phrase he or she. Mr. Butler moves to insert the following clause, the end of this compromise over slavery and navigation. Quote, if any person bound to service or labor in any of the United States shall escape into another state, he or she shall not be discharged from such service or labor, but shall be delivered up to the person justly claiming that service or labor. So throughout the convention and all its drafts, he is used to refer to president, vice president, senator. She appears only once and can be only one thing, a fugitive slave. That is the moment that the Constitution enters into a covenant, as William Lloyd Garrison would later say, it's an agreement made in hell, a covenant with death, an agreement made in hell. So, what are we to make of the Constitution and human freedom? Well, there's another narrative does not displace that narrative at all, but it is that the Constitution was literally a document at war with itself, and that while it both acquiesced in and facilitated slavery, it contained in its larger philosophy of government the seeds of slavery's demise. The creation of a government that rested upon the fundamental premise of consent of the governed, and which had among its central values human dignity and individual liberty, made slavery a constitutionally variant institution, even in 1787. The institution of slavery became even more anomalous with the adoption of the Bill of Rights as proposed by the first Congress. Now, what I mean by that is when we taught this course, when I would finish with the Constitutional Convention, John Hope Franklin would teach the next class, but skipping ahead to the 1840s and the fugitive slave cases. And more each year you would think, this thing is not going to work. It's going to fall apart over slavery. And boom, 1840. What happens? The problem of fugitive slaves is one good example of the tension built into the Constitution. When a person of color present in a free state was alleged to be a fugitive, he or she was entitled under either the 6th or 7th Amendments to trial by jury, the right to confront a witness, the right to be brought before an Article III judge if the proceedings were federal. Enforcement of these rights would have rendered the return of fugitive slaves difficult and in some areas of the country impossible. By the 1840s, juries in places like Pennsylvania were simply engaging in jury nullification and refusing to find that the person brought before them was in fact a fugitive slave, no matter how truncated the procedures called for by various fugitive slave acts. The Fifth Amendment, which provides that no person could be deprived of liberty without due process of law, is a clause that is hardly compatible. Now, pro-slavery lawyers marshaled arguments on the other side of these specific legal questions. Indeed, they argued that the Fifth Amendment's guarantee that no property shall be deprived without due process supported slavery. Chief Justice Taney argued in Dred Scott that slavery was distinctly and expressly affirmed in the Constitution, and that every debatable constitutional question ought to be resolved in favor of the protection of slavery. Therefore, you assume that even broad language, Congress shall have the power to make rules and regulations for the governance of the territories, does not include the power to forbid slavery in the territories. Hence, the Missouri Compromise is unconstitutional. But there was another way to read the Constitution, and to start with the fact they could not even mention the name of slavery. That it was seen as such an incompatible institution that it is always referred to as circumlocution whenever it is used as an argument for treating it as a variant institution and to read the Constitution against it at every point. That is, once the framers had conferred a sense of the dignity of persons the notion of having such a constricted view of who is a person in the real sense was part of that tension. Now, what road did Lincoln take? Lincoln and Frederick Douglass, the great African-American abolitionist leader, believed in reading the Constitution for the best it could be read to be, instead of taking the awfully legitimate course of William Lloyd Garrison, who thought it morally wrong to vote. Garrison urged every right-thinking person not to vote. To vote made you complicit in this constitutional regime. He burned his copy of the Constitution, and he said it's an agreement made in hell. Frederick Douglass urged people, particularly black men, where they were eligible to vote, to register to vote, to participate. Lincoln treated the Constitution as an inexact, incomplete, failed implementation of the original covenant, which he invented to be the Declaration of Independence. And that, of course, as you well know, is what is so brilliant about what he did at Gettysburg when, in Gary Will's view, with 230 words, he reclaimed American history. 7 years ago, our forefathers brought forth, but that's not the Constitutional Convention. That's not the date of the beginning of the government. It's back to the Declaration of Independence. So he says, this is the foundational covenant, it's the Declaration. And he says, all men are created equal. And at one point in the Lincoln-Douglas debates, Lincoln holds up a copy of the Declaration of Independence, and he says, I adhere to the Declaration of Independence. If Judge Douglas, his opponent, Senator Douglas, not Frederick Douglass, if Judge Douglas and his friends are not willing to stand by it, let them come up and amend it. Let them make it read that all men are created equal except Negroes. Let us have it decided whether the Declaration of Independence in this blessed year of 1858 shall thus be amended. And he stands on the Declaration and wishes to read the Constitution in light of that. Now, Lincoln was a good enough lawyer to know that the framers and the authors of the Declaration of Independence had no intention or thought that they were thereby freeing the slaves when they wrote, all men are created equal, and agreed to that document. But he insisted on referring to general principles of Republican liberty and equality embedded in the Declaration. He refused to assume that the framers were simply being hypocritical in proclaiming liberty and equality while acquiescing in slavery. And perhaps he knew, in a phrase uttered by my teacher in law school, Charles L. Black, hypocrisy may commit itself beyond easy retraction. Hypocrisy may commit itself beyond easy retraction. Indeed, what seems hypocrisy may reflect a commitment all along, no more than people do. Individuals know their minds all at once. By committing the nation to Republican principles, those are principles that cannot be easily cabined. And when the framers adopted a constitution that seemed to strengthen slavery, and did, they also provided larger principles of government that allowed those who came later to set the institution of slavery on the road to ultimate extinction. First and foremost, it created a powerful national government, which was truly an extraordinary achievement, a government with authority over the entire continent. And no matter how gerrymandered it was by 7 slave states with 2 senators apiece and a disproportionate representation in the House, the notion of popular government, the whole nation being large enough that you can't have tyranny on a local level. The idea of Madison of the extended republic as a source of national amelioration of local tyranny. His notion of the 10th Federalist comes to life in Montgomery, Alabama in 1956. It is the 10th Federalist. You can have oppression at a local level, but if you tyranny by the majority at the local level, but across the breadth of the great nation, it's much harder to maintain. The idea of constitutionalism, the government must be divided not by whim or even raw preference of majorities, all that comes together at one moment in our history, the winter of 1955, the day after Rosa Parks refuses to give up her seat on the Montgomery bus. The next day, the boycott was underway. And late in the afternoon, Martin Luther King, who was then only 26 years old and recently arrived, accepted the presidency of the boycotting organization, the Montgomery Improvement Association, and he was to address the mass meeting that night at the Holt Street Baptist Church. Coretta Scott King wrote later that she recalled his having only 20 minutes to prepare. What kind of argument does one make in that setting to show the wrongness of the preferences of the majority? Those with majority power had enacted this ordinance. Well, the best of the American constitutional tradition provided Dr. King with a kind of argument that is not available in many political cultures. And this is what he said to those packed inside and outside the Holt Street Baptist Church that November 9th. If we are wrong, the Supreme Court of the nation is wrong. If we are wrong, the Constitution of the United States is wrong. If we are wrong, God Almighty is wrong. The point is this, on September 17th, that the drafting of the Constitution in the Grand Federal Convention did not mark the creation of a just and democratic society, but the beginning of a quest that is not yet complete. Thank you. Thank you, guys. Oh, yeah, thank you. Who's in charge here? Do we have Are there classes? Do we have time for? Do we have time to take questions? All right, then, because I won't keep you long, but yes, Mr. Seagal.
Yeah, Walter, I wanted to get your take on a point that my students and I have been debating, which is the potential relevance of the 3/5 compromise to Tawney's argument in Dred Scott, that slaves are merely property and were always intended to be mere property and couldn't qualify as citizens. The idea being, what other form of property counts as 3/5 of a person for purposes of representation?
I think it actually helps Tawney's argument, or it at best is irrelevant. That is to say, the debate at the convention, they come very close, first of all, to deciding that representation, each state's representation size, should be by wealth of the state, not by numbers of people. Because, like shares in a corporation, not one person, one integer of a representative, but by wealth. Of course, it's very hard to calculate what the relative wealth is of each state, right? And so Madison makes the argument that the number of people is actually a very good surrogate for the wealth of each state. More people say government should represent wealth by far than say it should represent people. But Madison gets up and says we don't need to have this debate because the number of people is a sufficient surrogate for the amount of wealth produced, even though some states are per capita richer than others. And an amazingly sophisticated, I know we got some economics types, an amazingly sophisticated economic argument. He said because of the mobility of all of the factors that go into economics, because of we'll be creating national mobility, you will very rapidly even out the equation between the number of people and wealth. You won't have different economies like one does, say, between the border between Texas and Mexico, that once you have a completely free market, these will even each other out. So that the notion was that it undercounted the amount. In South Carolina, where there were so few non-slaves contributing productively, this is a black majority state at that time. South Carolina says, we're going to be contributing much more to the national economy because of the presence of slaves. So if you're trying to use the number of people as a calculus of economic development, then you need to count the productivity of the slave population, because it's a slave, because people are enslaved, they don't have the resources, and so we will reluctantly agree that the best estimate comes if you count the whole number of free persons. And look, they counted women, they counted children, none of whom were allowed to vote or have rights either. So the whole notion was to find some way of approximating each state's clout. That's all right going. Next time I come back, I think we should pick up the story, because we need to pick it up with Lincoln. Because Lincoln reimagined the Constitution in a rather extraordinary way, and I will end with this. He was able to re-envision and reimagine the constitutional system by these positive aspirations about it, and by adhering to a few principles. And whether you believe in a higher power or not, for me, I know no evidence of a higher power than that Lincoln appeared at the time he did to do what he did, and that helped lead to the reformation of the Constitution, to the war which followed with the 13th, 14th, and 15th Amendments, what Thurgood Marshall saw as a new beginning, a new constitutional foundation at mid-century. Well, thank you all very much.